We'll find out. Yeah.
Thank you. Please be seated. All right, that comes on for hearing the matter of EQT Production Company versus the Dodge County Commission, case number 12, C17. The parties identify themselves and state their representation for the record.
David Henderson and Steve Hastings from Walton Henderson on behalf of EQT.
Donald J. Tennant Jr. on behalf of the Dodge County Commission.
David Thomas Richardson, appearing on behalf of the HUD.
David McMahon, co-counsel for the House.
Thank you very much.
Excuse me, Your Honor, Brad Stevens is appearing on behalf of Jim and Jen Foster, interveners.
All right, this matter comes on today for a hearing upon the plaintiff's motion for preliminary injunction. In this matter, Mr. Henderson, you may proceed.
Your Honor, we have a few housekeeping matters left. Mr. Hastings can address this report.
All right, Mr. Hastings.
Yes, Your Honor, thank you. First, I'd like to present a stipulation of facts between EQT and Dodge County Commission to the court. And this is basically a stipulation of procedural history in this matter, Your Honor. We try to work out stipulations with all parties, and we're unable to do so before the hearing. That's not to say there wasn't some effort on all parties to try to do so. However, we want to streamline today, and we submit that stipulation of fact regarding procedural history up until today. Additionally,
Your Honor, the only thing I would, excuse me, Steve, the only thing I would add to that is the history that we could agree upon. That doesn't preclude us from putting on further evidence of procedural history. That's a great point.
that is really not. And Your Honor, briefly, I wanted to address something that the court brought to our attention last time on August 14th when we were here. The court indicated it did not believe it had jurisdiction here to appeal the decision of the Dodge County Commission. We think the court is incorrect in that regard, and I'm here to provide the court with some support on that. The court cited 5831 and indicated there were several factors which would give this court jurisdiction to overturn appeal. Washington Code Section 5831C states that an appeal shall lie to the circuit court of the county for the final order of the county commission in the following cases. Subsection C states the establishment and regulation of a road, way, bridge, public landing, ferry, or mill. Well, Your Honor, while the floodplain ordinance could arguably be a regulation of roads, ferries, and mills, we think the one that is closest on point in this case is a way. There's no question that the floodplain ordinance is a regulation of a way. So you're going to ask me for some support for a definition of way. West Virginia law does not define way. We look for it. So we went to ordinary usage of the word way. Floodway is a way. We did find some cases around the country that talks about a way. And Black's Law Dictionary finds a way. The definition of way generally includes, according to Black's Law Dictionary, as a passage or path. The World English Dictionary, 10th edition, 2009, calls it a route or direction. The World English Dictionary, 10th edition, 2009, defines a way as a means or line of passage as a path, track, or waterway. And there are Porter v. Armstrong's 1901 case, Your Honor, that talks about a way being defined as the natural flow of water as determined by the general superficies of conformation of the surrounding country, as distinguished from an artificial watercourse formed by the work of a man, such as a ditch or canal. In this case, the streams we're talking about are naturally forming streams. That's defined as a way. And I can report the site on that. 39 Southeast 799, North Carolina, 1901. There's no question that this ordinance is a regulation of a way. And in that regard, we think this court certainly has jurisdiction to hear the appeal, and we would ask the court to do so today. I would remind the court that in considering an appeal, the appeal shall be by trial de novo, which means that you get to hear everything fresh today, as if you were the body sitting, considering this ordinance. Even if the court, in addition to the court's jurisdiction over here, an appeal in this case, which we believe is clear, the statute, West Virginia Code 7-1-3B, which is the code section which establishes the authority by the legislature to the county commissions to enact floodplain ordinances, gives this court injunction authority, which the court has already indicated it would exercise. However, I want the court to be aware that the court can enforce the provisions of the ordinance by injunctive action. Therefore, we believe that the court can listen to the evidence and look at the ordinance as if you were hearing the evidence for the first time. If we comply with the ordinance, you can enforce the ordinance by injunctive action, not just prevent them from enforcing their orders. So we want to play that on the record before we proceed with our evidence today. And I'm happy to answer any questions the court may have.
All right, thank you very much, Mr. Hastings. Do you have any reply?
The position of the Douglas County Commission is to accept and not object to what Mr. Hastings has just presented.
Did you accept but not object?
Yes.
And not object. I'm curious to see how we have a way, considering there's no delineated floodway at issue here. I admire the argument that Mr. Hastings made, that given there's no authority and the court has already made a ruling regarding whether there's going to be an appeal, I just don't see how we're going to make it to overcome your previous rule. Citing 1901 North Carolina case and the planning definition of way and applying it to something that doesn't even exist in this situation. Technically, there is no floodway. So I just don't see how that's relevant to our discussion or argument about floodway.
All right, thank you, Mr. Richardson. Mr. Mann, any response?
Well, I would put it,
They represent the same entity.
Oh, I'm sorry. Okay, go ahead. All right.
Mr. Stevens is the only other one, I think, on our side, the other side of the Your Honor.
Okay, thank you. All
I
right.
have nothing to add, Your Honor.
Your Honor, I may agree with this one. You have points, Mr. Richardson. One, I'm not sure the court made a ruling. I think it was just a statement on the record. There was never really discussion over in the court advising it of what his belief was as to his jurisdictional authority. Second, I'm not just talking about floodway. We agree there is no floodway in this case, and I think that's going to be important later today. However, this is a waterway. And my definitions that I presented to the court as ordinary use of the word way clearly includes these streams that are at issue. And the regulation is for floodways in addition to waterways, in addition to floodplains. And so I don't think there's any question it's way. I mean, what else did the legislature mean when it meant road, way, mills, ferries? Ferries generally is, I'm still relatively young, Your Honor, and I haven't seen ferries around West Virginia, but I'm assuming those come across water. And these will be regulations of waterways and things like that. And that's the purpose of the statute. And it makes sense. Why does it make sense? Because if the county commissions do something, the first stop should be here in the circuit court of Douglas County, as opposed to running straight from the county commission to the Supreme Court. And it makes sense, and that's why we believe that the court should entertain that jurisdiction in addition to the sound law. Thanks.
All right, well, Mr. Hastings, let me touch on a couple of things in that regard. I think 713B does directly address injunctive authority, but I think, as you alluded to in your argument, I believe the injunctive authority that is addressed in that provision speaks to the enforcement of orders of the commission, the appeals board, with regard to the floodplain ordinance. Is it not?
Your Honor, I actually have a copy of it. I'll read this entire sentence for you. Any such building code, which is what we're talking about, adopted by a county commission and other requirements imposed by a county commission under the provisions of this subsection C may be enforced by the injunctive action of the circuit court of the county. And I have a copy for the court. It is saying that the building code may be enforced. not the orders. If you would like to comment,
Okay,
second.
all right, now that's all right. I haven't read that and just haven't recalled that clearly. All right, and I don't think there's any question about being here for purposes of a proper hearing on an injunction. And I guess what I would like to maybe address with you, Mr. Hastings, and have you address, is we're definitely talking about an issue here that involves a way. I think I can concede that. I think that's well established and pretty clear. But is this ordinance with regard to the issuance of drilling permits, doesn't it really govern the issuance of drilling permits with a consideration of various different factors which include but are not limited to the effect of floodways upon whether or not that permit should issue, as opposed to regulating a floodway? Because I think, the ordinance here doesn't have to do with the granting of the way or the establishment of the way. It has to do with the impact or effect that a floodway would have upon the propriety of issuing a drilling permit. And I guess in that sense, it may be a factor to be considered, but I don't think it's necessarily, just as I sit here and think about it, as a matter of first impression. I don't think it's necessarily the substantive issue that's addressed by the ordinance, and the parties are in disagreement with that.
Your Honor, with all due respect, I believe the court may have it backwards. If I may, the federal government has a national flood insurance program. FEMA, generally, people talk about in order for disaster relief in the event of a flood, in this case. And the West Virginia legislature has to do something in order to make sure that the state complies with FEMA. The legislature has given that authority to the county commission. There's really no disagreement in any of this, I don't believe. And so the county commissions must make sure that building activities don't affect ways, floodways, floodplains, or river streams. It's not that the floodplain won't affect the development, or the floodway won't affect the development. It's whether this development will affect the way. And so, and we may be talking about the same thing, Your Honor, but I believe the issue in this case, the substantive issue is there is an ordinance. And can you comply with this ordinance? Because if you comply with the ordinance, you get a building permit. So you look to the language of the ordinance. Because the ordinance is to protect the waters. There are other aspects of the ordinance, but this is what we're talking about. So I think there's going to be a distinction as to whether this is a floodway and a floodplain, and those differences and definitions mean something in this case. And can you do something in a floodway or floodplain? And if you do it, what effect does that have on the simple question of increasing the risk of flooding? Is a simple question.
Well, the provision that you cited that you claim provides for an appeal of this issue, doesn't it have to do with the establishment of the way?
No, Your Honor, it says that the establishment and regulation of the way. So what in effect is what the county commission is doing is they establish an ordinance regulating the way. And in their permitting process, they say you have to go through certain steps. You go through certain steps, and then there's appeals. What they're doing now is they're regulating the ordinance. Their interpretation and regulation of ordinance. And that's clear under 5831 that this court will have jurisdiction to hear an appeal. If, on that issue, I'm assuming that this circuit court can hear an appeal either way on this, and it's trial and over. And again, I would suggest it makes sense, Your Honor, that this court would have the jurisdiction over the county commission. Because, again, there's a logical step before running the circuit Supreme Court on every building permit in the county.
All right. Thank you. That argument is persuasive. It does appear that upon further consideration, that might be proper for this court to entertain. What I'm going to do is stop short of actually finding that, permit the parties to move forward with regard to the evidence, and further consider that matter.
Your Honor, just a point of clarification, just so everyone's on the same playing field. Are we today going to conduct the trial de novo on the appeal? Or are we simply hearing the irreparable harm injunctive relief motion that's been filed? I just would like to know that as soon as one witness takes a stand.
I think the evidence is going to be the same no matter what. Now, pretty seriously, it would differ much. The reason for entering the stipulation, quite frankly, Your Honor, was to get a lot of procedural history and facts and come up with stipulation so we could get to the meat of the issue, which is really whether or not we comply with the floodplain ordinance.
Mr. Richardson?
Your Honor, I have to clarify the language. The way, it's the establishment and regulation of road, way, bridge, public land, fair, no, not for. I just believe Mr. Lee is making the argument that the establishment or there's regulation and the floodplain ordinance is regulating a way, therefore it's under that. Further, we seem to all deal with transportation, a road, a way, a bridge, a public landing, a ferry, well, not a mill, I'll take that back. But they're not dealing with flooding. And further, if the legislature wanted a floodway, they would have put a floodway. It's pretty simple. But again, establishment and regulation. Thank you.
Mr. Stevens, did you have something?
No, Your Honor.
All right. Well, as I mentioned, when we were here in August, a lot of this evidence may be the same either way on the same issue. I guess the only question that would still be before the court in this regard would be procedurally whether or not anybody thinks they might be aggrieved not having proper notice for purposes of these proceedings, that this might be appealed for purposes of considering the propriety and conducting a hearing de novo on the issue as to whether the commission should have or incorrectly did not issue a floodplain drilling permit in this case.
I don't think anybody should be prejudiced, Your Honor. I mean, we've beat this around about as much as we can. I mean, we have literally stopped and started this project at least a half a dozen or more times in between people drilling water wells in the middle of our area to drill our oil and gas wells, to come in here to refiling what we thought we already filed with the floodplain information and studies, to letting them go out and get whatever they thought they needed to get in order to counter what we have. And so I can't believe that anybody can be surprised with what we're going to do here today. Quite frankly, Your Honor, it's after you hear the evidence, since we're trying to sit the bench, you're going to apply whatever standard you think it needs to be applied at this point in time.
You guys care to follow that?
Your Honor, we were preparing for a preliminary injunction that was going to deal mostly with irreparable harm and lack of adequate remedy of law per your instruction at the last hearing. I only asked if we have a moment to discuss and see if we have an issue.
You may just take as much time as you need.
Thank you.
All right. Court will briefly be in recess.